All right. So welcome everyone to the Houston Area Urban League Virtual Expunction Clinic. We wanted to host this morning to provide a way for our community to help clean up their records. Oftentimes people go out and try to apply for jobs, apply for housing, apply for licenses, and then they are denied because of hiccups on their record. Now, there are ways to take care of that. And so today we wanted to share with you all how we can take care of that. We wanted to provide information that hopefully you all will use. And, if you have any questions, let us know, because we're all a family here and we want to make sure that everyone is taken care of. So I'm going to go ahead to Marta, who will introduce the speaker. And also, if you have any questions at any time, please drop those questions in the chat, so that way we can respond with you all. If you feel that you have some private questions, please select the individual you want to send the question to, either myself, Markia, or the Houston Area Urban League Professionals account. You can send it to that, and that way we can answer your questions in private, because we understand this is a private matter. Some people don't want to share this with everyone. So again, if you have any questions, please select who you want to send the question to, and we will be able to return those questions. All right, Markia.
Thank you. Welcome, everybody. So I'm going to introduce Professor Ashworth and then pass it over to her to get started. So Kimberly Ashworth is a 2012 graduate of the University of Texas School of Law, and she has been a public interest attorney and adjunct professor at South Texas College of Law, Houston since 2014, and she is now serving as an assistant public defender in the Holistic Services Division. Attorney Ashworth has been working in the area of expunction and non-disclosures for the past several years, and her primary focus at the Public Defender's Office is removing barriers to employment and housing, including cleaning up criminal histories. I've had the pleasure of working with Professor Ashworth. I'm sad to see her leave South Texas, but I'm excited for her future, and I'm excited for the presentation today. So Professor Ashworth, take it away.
Excellent. Thank you, Markia. I'm going to go ahead and share my presentation, and please feel free, I'm very informal, so if you have questions during the presentation, absolutely feel free to raise your hand or ask any questions that you may have. There are going to be some slides that I'm going to kind of skim over, just because in my experience they don't apply to most of the people that I encounter. So I really want to focus on the most common areas of expunction and non-disclosure. So expunctions are going to be in Chapter 55 of the Texas Code of Criminal Procedure. And what's really weird about expunctions and non-disclosures is while they're directly dealing with people's criminal history, they are actually considered civil forms of relief. So it's not technically a criminal case. So what is an expunction? It's a court order, and that requires the destruction of records related to the arrest. And that means that every record will be physically destroyed. So it only applies to the people that you name in your petition. And so it's really important to name everybody that you think may have records. So every law enforcement agency that was involved with the arrest, anyone that you came in contact with in the criminal justice system, whether that be pretrial services, a community supervision officer, any public law enforcement agency should be named in the petition. If you don't name them, then they don't have to destroy the records. And it doesn't hurt you to over-name people. I mean, there's no downside to that. So the benefits are that you don't have to disclose the offense on any employment or licensing application, which is really beneficial. The public entities cannot disclose the criminal record. And you can deny that you were arrested and you got an expunction. The only exception is if you're questioned under oath at a criminal proceeding, then you at least have to say that it was expunged. The one caveat to this is that we always recommend that people who are in the country without a legal status, that they consult with an immigration attorney before they ever file any paperwork with USCIS, because the FBI and the federal government may still be able to see these records. And so we never want somebody who is applying for status to get in trouble for not disclosing something. So always consult with an immigration attorney if that applies to you. So this is one that doesn't really apply to a lot of people, but you do get an expunction if you're acquitted at a trial court or you get pardoned by a higher court. So you take your case up on appeal and they undo the conviction. This area is going to be the most common. So if you are released without a final conviction or community supervision and the charges are dismissed, and the only type of community supervision you can get is if you're on a Class C type of deferred adjudication. So basically those are ticket-only offenses, and you get some kind of, 60-day probation, something like that, then you can still apply. If you are not formally charged, so the indictment or information is never presented or filed, then you can get an expunction. The district attorney always has the ability to agree to an expunction, and whether or not they're willing to agree to expunctions is going to depend just sort of on the attitude of the district attorney at the time. If you're charged, so you're formally charged, but you have a dismissal for a qualifying reason, or the charges are dismissed for any reason, and it's been so long since the case was filed that the state can no longer prosecute, then you're allowed to get that under the statute of limitations expiration. So if you are arrested and you get charged for multiple offenses, so I see a lot of this with my clients who get stopped for driving without a license, and then when they're taken to jail, they're found with like a joint. So then they have both a charge for driving without a license and then also possession of marijuana. Both of those charges must be eligible for an expunction to have the entire arrest expunged. So if you have a case that an arrest that has multiple charges and you plead guilty on one, so you have a conviction on one charge and a dismissal on the other charge, you cannot get that dismissal expunged. Some DAs will agree to do basically what's called a partial expunction, where they're willing to take the records for that dismissed charge. Harris County no longer does that. And again, there's also expunctions if you're tried, convicted, and acquitted by a court of criminal appeals, or if for some reason somebody has stolen your identity and then they use that to get arrested, then you can get an expunction as well. I have not had a lot of experience dealing with these areas, just because, again, the most common is people who are charged and then the charges get dismissed. So if you are arrested for violating your community supervision or probation, that arrest cannot be expunged. If you're acquitted, but again, that offense arose out of a criminal episode and you still have pending charges or convictions resulting from that same arrest, then you cannot get an expunction. And there are limited options if you are arrested for jumping bail. Harris County is actually very good. If you have a dismissed case that has some bond forfeiture cases associated with it, they're going to combine all those and make sure those get expunged as well. The easiest way to identify those is if you do look at your criminal history, it will have the same case number as your underlying arrest, but it'll have an A at the end. The A stands for associated. So if you're not charged, again, so no indictment, no information, basically you're arrested, but the DA declines charges. Or perhaps you have a felony case and the grand jury says, we're not going to indict this person. That's called a no bill. Then you would fall under this category. Basically, you have to wait a specific amount of time before you apply for the expunction. It's 180 days for Class C misdemeanors, a year for Class A and B misdemeanors, and 3 years for felonies. The state can also certify that the records are not needed in an investigation and you can get an expunction. The downside about this expunction is that you are getting it before you've ever been charged, which means that the state can still come back and try and prosecute you. And they are allowed to keep the records for the purpose of later investigation. So what we tell people is if you're going to go for an expunction under this statute, then you need to come back once that statute of limitations has expired. So once the state can no longer prosecute you, and get a second expunction. That way all the records will be destroyed. But certainly there are reasons why you may want to immediately try and get something expunged from your record, like you're applying for a job, you're applying for housing. Definitely take advantage of this. This is the one that I use the most often. And so, been charged, and then the charge gets dismissed. If it's dismissed because you do a pretrial diversion program, and Harris County has a lot of pretrial diversion programs for drug offenses, theft, there's one for prostitution, there's some for assaults. If you do one of those programs and your charges get dismissed, then you would qualify under this statute. If you're a veteran and you get put in Veterans Court and you complete that program, they are actually handling all the expunctions within that court itself. So if you are a veteran, you have a pending case, make sure that you ask to get identified as a veteran and that you get put in the Veterans Court program, because they are providing a lot of services and, again, handling all the expunctions in-house. If you had a charge that you were charged and then it was dismissed because of mistake or false information or reason showing lack of probable cause, you can get an expunction. This does not mean that somebody's missing. Like, so maybe a witness is missing or the state can't prove it beyond a reasonable doubt. That doesn't count. What I'm usually looking for is, I do have clients who sometimes get arrested for possession of a controlled substance, but they have a valid prescription for that drug. So they show up in court, they show the judge their prescription, it's dismissed. Well, they didn't actually commit an offense. Like, they weren't really in possession of a controlled substance because they had a valid prescription. You can go under that one. If somebody lied and you got charged, that would be a reason showing lack of probable cause. Or the indictment or information is void. So the easiest way to figure out how, like, the reason for your dismissal, if you can't remember, is you can log onto the district clerk's website. You can see all the documents in your case. Just pull up the dismissal order. It'll say a reason. If you're dismissed because, or the charges are dismissed because you were convicted in another case, or for really any other reason other than the ones on the prior slide, what you're going to have to do is wait for the statute of limitations to expire before you can get an expunction. So to calculate your statute of limitations, you can look it up in the Texas Penal Code. For higher level felonies, it's going to, anywhere from like 10 years to there is no statute of limitation for murder. Most felonies are about 3 years. Most misdemeanors are about 2. You can always double check. What I tell people is you count the months from the date you were arrested to the date that you were formally charged, and then the statute of limitation pauses. And then you count the months from the dismissal until today. And then you add up those 2 windows and you make sure that it meets the statute of limitations. The other easy way is just to add 2 years, 3 years to the date of dismissal, and that gives you, that will guarantee that you're past the statute of limitations. So these are going to be filed as an original civil case with the Harris County District Clerk, and it's going to be filed in District Court of the County of Arrest or where the offense occurred. So here we file them with the Harris County District Clerk, and they're going to be heard by our district civil courts. If it's a fine-only offense, so your Class C tickets, you can file in justice or municipal court. The one downside to those is that they really do not accept affidavits of indigency or pauper's affidavits, which means you have to pay the filing fees. Most of my clients qualify to have all the fees waived by filing a pauper's affidavit or affidavit of indigency. And so it's free if we go into district court. So I'm most likely going to be filing all of mine with the Harris County District Clerk because I don't want to pay fees that I don't have to pay. It has to be verified. That means that you have to sign it in front of a notary, or because of COVID, we're using a lot of unsworn declarations. And that is basically your declaration that everything is true. You're swearing under penalty of perjury. You need to have a signature block that has your name, your date of birth, your address, and that everything you've said is true and correct under penalty of perjury. You date and you sign it, and that will count. It has to include all of your personal information. So you do want to make sure that there is a notice at the top of your petition that says, notice this document contains sensitive data. The reason you want to do that is because the district clerk will take that information out before it becomes publicly available, because you don't want everybody in the world seeing your social security number. But you have to have all your personal information, all the information about the case, date of arrest, who arrested you, the charge, the case number, the court number, all of that. And anybody that may have information about the case. So the most common ones in Harris County are going to be the district clerk, who maintains all court records, the Harris County Sheriff, who runs the jail, the district attorney, who prosecutes both felonies and misdemeanors, Texas Department of Public Safety, they run the state level criminal databases, the Office of Court Administration. They're an online entity that has a public website, so you want to make sure that they get notice so they destroy their records. And then whoever your arresting agency is. I also include pretrial services in Harris County just in case there was any kind of pretrial diversion or any contact basically with that agency. I want to make sure that the records are destroyed. If you have a drug offense, you want to include the agency that tests drugs in Harris County, which is the Houston Forensic Science Center, and really anybody else that you think may have records. So sometimes I have clients who got arrested out in Fort Bend County, but it was a Harris County case. So not only do I have to include, the agency that originally had picked up the case, so Houston Police Department, I've also got to include Stafford Police Department because they're the ones who arrested the client. So anybody you've come into contact with on that arrest, include them in your case. You don't have to have a hearing unless somebody objects to the application. And so if an objection is filed, then there's a 30-day notice by certified mail, email, or fax. You do have to notify them. You have the burden of proof at the hearing. My experience in Harris County has been that you file your petition, you file an order setting hearing. The courts are going to set it anywhere from 30 days to a couple months out. It depends on that court's docket, that court's availability. About a week or so before the hearing, the district attorney is going to review the application. They will not review it before then. They'll file what's called an answer, so they'll file their response, and then they'll notify you if they're in agreement or not. If they're in agreement, they send you an order that's a fill-in-the-blank order that you complete and send back to them, and you're responsible for collecting all the different signatures. If it's contested, then you have to go to the hearing and appear and prove your case. My experience, though, is the district attorney, if you make sure that you meet that statute, they're not going to object. They're going to send you an agreed order. And if the DA agrees, everybody else agrees, basically. The order has most of the same information as the petition. So all of your identifying information, the information about the case, the information about all the named entities, so the respondents. You have to make sure that whoever's included in your petition is included in your order. And you cannot add anybody new in your order. So if you want to add new people after you've already filed, file an amended petition, add those extra people, and then your order can include them. So when can law enforcement or the district attorney retain records after you've gotten an expunction? It's automatic with a waiting period expunction. Again, they can keep all the records. Or they can get court approval. So if the records have been expunged, then the state comes in and says, Judge, we need these for investigation of any other offenses arising out of the transaction or to investigate third parties, and they show that they really do need these and it's a good faith claim, then the court can allow them to keep them. They can't just keep them for any reason. They do have to show that they intend to pursue an investigation in order to get these records. All right, before we go on to expunctions, I just wanted to check and see if there were any questions.
Well, I had a question.
Absolutely.
I see that on one of your slides, you had mentioned list of different agencies, and you also had NCIC and FBI. Now, if the FBI is involved on one of those cases,
so
how do we list that?
So they are going to be notified by DPS, and so I can go back to that slide. So NCIC and FBI are automatically going to be notified by DPS, so you don't actually have to name them in the petition. So the Texas Department of Public Safety will notify everybody and tell them to destroy them. So you shouldn't have to worry about that. If you have a federal offense, the federal FBI is bringing the charge and you're charged in federal court, this does not apply.
Okay.
These expunctions are only for state cases. So if you're in the federal system, you have to look at the federal laws about whether or not you can get any sort of expunction or relief. Any other questions? Okay. So non-disclosures,
I had a question.
Oh, absolutely.
I dropped it in the chat, sorry. And here, I'll turn my video off. Hello. My question is, when you're naming the arresting agency and uh, kind of naming everybody,
Mhm.
if you have the name of the arresting officer, is it required to include them, or is it just good prudence to include them if you know that information?
So I just include Houston Police Department because like Officer Smith doesn't mean like his records are Houston Police Department's records. He's an officer. So when I say that HPD must destroy the records, HPD must ensure that all the records are destroyed. So just naming the agency will be sufficient. And also I would have no idea how to find out who the arresting officer was. Like I've never seen that in the offense reports or anything. One tip I did want to share is in the order, it will ask you for the offense report number. You can pull that from the original indictment or information that's filed. It'll be at the top corner. It'll say who arrested them and who the arresting agency is. And if you aren't able to find documents, so like the older the cases, the less likely it is that there's going to be any records. If you go to the activities tab on the Harris County District Clerk's website, so like you run the search, you pull up the case, go to activities, it should have a list and it'll say who arrested and the offense report number. So that's a really useful tool as well.
Thank you very much.
We also have another question. That question is, if I have a case that violated moral turpitude, like a DUI, but it shows as a dismissal, would you recommend an expunction to prevent me from losing jobs, or is it a dismissal enough?
So I think with a lot, it depends on the job itself. So some employers ask you on employment applications, have you ever been arrested? In which case you would have to say yes, and you'd have to disclose that you were arrested for a DUI. And then you can probably say it was dismissed. If you have a DUI and it was dismissed, then you're probably entitled to an expunction. And I would encourage you just to go ahead and get it, because then you can deny that you were ever arrested on any employment applications or licensing applications. So if you feel like it has perhaps been holding you back, you should definitely, look at whether or not you can get an expunction. And I'll also tell people, if you're applying for a job and the employer says like, we can't hire you because of your criminal history, you are legally entitled to a copy of that background check. And so usually you have to request it within a certain amount of time in writing, but follow up with whoever you're speaking to about the job posting and say, I want a copy of that background check. You can double check to make sure it's correct. If the background check has included information that you've already gotten expunged, you can notify that company and say, hey, here's my expunction order. You need to destroy this from your records. All right, so non-disclosures. So non-disclosures are a little bit different. They're still court orders, but they don't require destruction of records. What they do is they seal records. So once something has been non-disclosed, it is sealed from public view. It's exempt from public information requests. It's taken off the district clerk's website. It's really beneficial, but the record still is there. It still exists. It's just kind of behind a firewall. There are template forms that are required to be published by the Office of Court Administration, which is a state agency, and that is really nice. And I have their link at the end of the presentation. So the benefits, again, you don't have to disclose it on an employment or licensing application. The information is exempt from open records requests, and public entities cannot disclose the criminal record to anybody. So there are, of course, exceptions to that rule, which we'll talk about later. And then you can deny that you were arrested and prosecuted unless the district attorney uses that information against you in a later criminal hearing. Then you do have to admit to it. So I just want to quickly go over some common terms so everybody's on the same page before we get into it. So deferred adjudication refers to cases where you enter a plea of guilty or nolo contendere, but the judge basically keeps the plea and puts you on some sort of supervision with the court from anywhere from 6 months to 5 years. If you successfully complete that, then they dismiss the proceedings against you and they discharge you. So this is a different kind of dismissal than the ones we were talking about for expunction. Expunction are cases that basically was an arrest and then like a dismissal pretty much immediately. With non-disclosures, you're looking at cases where you've gone further into the criminal justice system, where you've actually entered a plea, you've done some sort of community supervision, and then because you successfully completed it, the judge allows you basically to take back your plea and dismisses the charges against you. So a discharge and dismissal, this is the satisfactory fulfillment of the terms of your community supervision or deferred adjudication, and the period has expired and the court discharges you and then dismisses all of the charges against you. This is really important because if there's a waiting period associated with your non-disclosure, this document is what triggers that waiting period. It is never called a discharge and dismissal in court records. What you'll see is orders affecting community supervision. That's what you're looking for. And then when you read through it, at the top, it'll have the language about being discharged, and then it'll have the dismissal at the bottom. So best interest of justice, you'll see that pretty much every non-disclosure must be in the best interest of justice. It's of course not defined in the law, but we do know that there are times when the non-disclosure is not in the best interest of justice. So if you have received deferred adjudication or convictions for similar offenses, so I've seen arguments that if you have a bunch of thefts on your record, your employer or the society should know that you commit theft, so we shouldn't take any off your record. Or if the case had really particularly egregious facts, we see that a lot with any case involving child victims. A lot of times people plead to lower level offenses. The judge is allowed to look at the original case file to see what was involved in the case before they make a decision. But things that are in the best interest of justice that I've argued are that my client can't get a job, they can't get housing, the social stigma of certain arrests. So I work with a lot of survivors of human trafficking, and having a bunch of prostitution convictions on your record, like, people are going to judge you pretty harshly for that. And so we've used that successfully to say this is in the best interest of justice. And I would say that most people would agree that getting any criminal history off your record does help you in a positive way. So it is in the best interest of justice. And a lot of our judges in Harris County do understand that argument, and they're pretty open to these. So the mandatory requirements, and these apply to every non-disclosure except for non-disclosures if you are a victim of human trafficking or compelled prostitution. So you cannot have a conviction or deferred adjudication for another offense during your jail sentence, during your period of deferred, or during community supervision. So if you pick up anything else during that time period, you're ineligible. That offense is ineligible. If you pick up a new conviction or deferred adjudication in the waiting period, after you've completed your jail sentence or deferred adjudication or community supervision, that offense is ineligible. And then you cannot have a previous conviction or deferred adjudication for a disqualifying offense. Subsection B does apply to trafficking non-disclosures as well, only subsection A, they don't have to follow. So this can be really hard for people. So if you, like, I've had clients who had a felony deferred adjudication. So they were on felony deferred adjudication for 5 years and then had a 5-year waiting period. So there was 10 years where they could not have any other convictions or deferred adjudications. And if they picked anything up during that 10 years, that offense stayed on their record. So it's really important to look at that whole time period. If you have arrests that result in dismissals, that's fine. That doesn't count against you. The disqualifying offenses are any offense requiring registration as a sex offender, aggravated kidnapping, murder, human trafficking, injury to a child, elderly or disabled person, abandoning or endangering a child, if you're arrested for violating a court order or bond in a family violence sexual assault case. So if you violate a protective order, you're ineligible. Stalking or any offense involving family violence. And what's important about these is that if there's a disqualifying offense in your criminal history, you are forever ineligible for a non-disclosure. It is very harsh. I had a really hard case on Friday where I had a client who was a trafficking survivor. We thought we were going to get all of her prostitutions off her record. At the hearing, learned about a violation or an arrest for a violation of a protective order that resulted in a conviction. She was ineligible. Everything stayed on her criminal history. So you want to double check your full criminal history to see if you have any of these disqualifying offenses. So there are a lot of options for non-disclosures, and it can get kind of overwhelming. So what I like to tell people is look at your first offense. So the very first thing on your criminal history. If it's a misdemeanor and you don't have serious later criminal history, so you don't have a bunch of felonies, Then you can look at the options for first-time offender non-disclosures. So there are options for certain misdemeanors that resulted in deferred adjudication, that resulted in a conviction plus probation, that resulted in a conviction plus jail time. There are options for DUIs, both for deferred adjudication, community supervision, and jail time. If your first offense is a felony, it's not going to, none of these will apply. If you have any other cases in your criminal history that are convictions, so you took a straight plea, you got time served, you served community supervision, those will never come off your record unless you are a human trafficking survivor. So basically, the only time a conviction can come off your record is if it's your first offense and it's a qualifying misdemeanor. Everything else, you're looking just for deferred adjudications. So I'll quickly go through our first-time offender non-disclosures. So again, no prior convictions. You have to receive and successfully complete deferred adjudication for a qualifying misdemeanor. So it's not boating or driving while intoxicated or some higher level misdemeanors like organized crime, things like that, prostitution. The judge can't have made a finding that a non-disclosure under this subsection is not in the best interest of justice. You have to successfully complete your deferred adjudication, get your discharge and dismissal, meet the mandatory requirements. So no other convictions or deferreds during your period of deferred adjudication or the waiting period, no disqualifying offenses, and you have to wait at least 180 days. Then you can get under this one. If you resulted in a conviction, so again, not the boating or driving while intoxicated or operating an amusement park while intoxicated, organized crime, if you give alcohol to minors, that's exempt. And you successfully complete your community supervision. This includes completion of any payments, fines, or restitution, which is hard for people. I have had clients though where they wound up serving some jail time to pay off their fines, and that's counted as successful completion. So always double check to make sure you've paid off all your fines before you apply. Again, the mandatory requirements, the waiting period has elapsed, and it's going to be either, it's 2 years for higher level misdemeanors, and then no waiting period for most of your lower level misdemeanors. And the higher level ones are things like assaults, prostitution, stuff like that. And you have to prove it's in the best interest of justice. And you'll see the next one, remarkably similar, except that it includes not violent or sexual offenses, and you successfully complete your jail sentence. So the main difference is the one on the prior slide is if you get community supervision. This one is if you get like time served or 60 days in the county jail. You would apply under this statute, but very similar. Again, you have to meet the mandatory requirements. The waiting period has elapsed, and the waiting period is 2 years from your completion of your sentence. So 2 years after the release. And again, issuance of the orders in the best interest of justice. So for this one, which again, these all came up in 2019, so they're brand new. Most judges have never heard of them. No prior convictions or deferreds. And this is for your while intoxicated offenses, so driving or boating while intoxicated. If you get deferred for that, and there's no affirmative finding that a non-disclosure is not in the best interest of justice, you did not cause an accident involving a third person, you can apply. You do have to successfully complete your deferred adjudication and obtain a discharge and dismissal. You have to meet the mandatory requirements, and it's a 2-year waiting period. And again, issuance of the orders in the best interest of justice. So this is if you receive community supervision for only driving while intoxicated. So we had more options if you got deferred. It included boating as well. For the community supervision or jail time, it's just driving while intoxicated. You have to successfully complete payment of all fines and costs. You can't have caused an accident involving a third person. You have to meet the mandatory requirements. The waiting period has elapsed, and that's going to be 2 years from the date that you completed your probation if you had an ignition interlock device for at least 6 months. If you didn't have an ignition interlock device, it's 5 years. You also can't have a blood alcohol level of more than 0.15. So if you have a really high blood alcohol level, you're not going to qualify under this statute. And again, issuance of the orders in the best interest of justice. So this is if you're convicted of driving while intoxicated, you serve a jail sentence, meet the mandatory requirements. The waiting period is 3 years if you had an ignition interlock for six months, 5 years if you didn't have an ignition interlock.
We also have another question. A private citizen with very basic law knowledge, can I apply to have my record sealed while I'm awaiting for an expunction?
Yes, so they would be kind of two separate things. So if you've already, I do this a lot, like I've already filed my expunction case, I'm waiting on my order setting hearing to come through, but I'm also going to file my non-disclosure at the same time. I absolutely will do that. I just make sure that the district attorney, when I show up at my non-disclosure hearing, that they're aware I've already applied to get those records expunged. If I'm getting a lot of stuff off people's criminal history, what I may do is say, like, let's hold off on the non-disclosure till we get the expunction order done, then let's go in and do the non-disclosure. There's no right way to do it. You're absolutely able to file them at the same time. You just kind of have to weigh what you think is going to look better for the district attorney. And then, of course, yeah, issuance of the orders in the best interest of justice. So again, if you have evidence of causing an accident involving a third person, you're not going to be allowed to apply under those DWI non-disclosures. So this is the one that's most common. So again, all the ones that I just went through, and I know I went through them really fast, that is first-time offender, first offense. So your first offense has to be a DUI if you want to get a DUI non-disclosure. Everything else, misdemeanor, first-time offender, then you can apply under those statutes. For the rest of your criminal history, this is the only statute that's going to apply other than human trafficking. So if you receive and successfully complete deferred adjudication for a qualifying misdemeanor or felony, driving and boating while intoxicated do not apply. And you're not eligible under the very first statute, which is easy to prove because if it's your second, third offense, it wouldn't qualify. You have to successfully complete deferred, obtain a discharge and dismissal. You have to meet the mandatory requirements. The waiting period has elapsed. For most misdemeanors, it's immediate. For some higher level misdemeanors, it's 2 years. So that's things like assault, kidnapping, prostitution, harassment, unlawful possession of a weapon. Those are all a 2-year waiting time. And then 5 years for all felonies. So if it's a felony, it's 5 years. And you have to prove that the issuance of the orders in the best interest of justice. And so I use this one a lot. This is the one I go to. Like, I'm always looking for deferreds that resulted in a successful completion. If you get a deferred adjudication that you do not successfully complete, it doesn't qualify. So for human trafficking, which is the only other way that you can get convictions off your record. If you were convicted or you received deferred adjudication for low levels of delivery of marijuana, so less than a 1/4 ounce, possession of less than 2 ounces, class B or C thefts, and then any level of prostitution, so A or B, or A, B, C, or felony. If it's one of these 4, then you can look at the human trafficking statute. If you were asked by law enforcement or the DA to help with an investigation or prosecution, you have to have complied. Sorry. And that's the only exception is that if you didn't provide assistance due to age or a disability that resulted from being a victim of human trafficking or compelled prostitution. You cannot have any convictions or deferred adjudications for one of those disqualifying offenses that we talked about earlier. You must prove that you committed the offenses solely because you were a victim of trafficking or compelled prostitution. And compelled prostitution is basically somebody uses force or coercion or threats. They get you addicted to drugs and then withhold those drugs to force you to engage in prostitution. Or if you are under the age of 18, that's compelled prostitution. The waiting period is a year from the conviction. So yeah, 1 year after completing the sentence, you do have to pay all of your fines and costs and the issuance of the order is in the best interest of justice. And the one that I use most common for that is that if you are compelled into prostitution, you were a victim. So you weren't committing these offenses, so it's unfair for us to burden you with these convictions. And if you've applied under this subsection before, you can't have any convictions for one of those 4 offenses that we talked about on the first slide for this section since the date that you filed this application. This application only came out in 2019, so it's unlikely that people have even filed these. We just started filing them this year, which is a new adventure. So for a non-disclosure, you're going to file a written petition with a proposed order and an affidavit or declaration of indigency. The petitions are filed in the same court and the same cause number as the underlying criminal case, unless you're in Fort Bend County, in which case they make you file it as a new civil case, which they are not supposed to do, but they do it. So don't be surprised if in Fort Bend County you get pushback from the clerk when you try and file this. The court is supposed to provide notice to the state. In my experience, the DA never gets copies of these, so you want to try and make sure that you get a copy to them somehow. And the easiest way is to ask the court coordinator who are the ADAs assigned to the courtroom, and then send them an email or ask for the fax number for the district attorney's office and send them a copy of your petition. The state has 45 days after receiving notice to request a hearing. Harris County sets you automatically for a hearing within 1 to 2 weeks. They probably will not give you notice. I know they don't give me notice. So you need to check online through the Harris County District Clerk's system to see if there is a hearing set. If you don't have access to the internet or you're not familiar with the Harris County District Clerk's website, I would just call the court about 2 days after you file your case and ask, is there a hearing date set? And they'll tell you the date and time of the hearing. Pretty much everything right now due to COVID is through Zoom. And there are online websites that show the links. The felony courts will email you the link. The county level courts are, if you just Google like county criminal courts at law, like live stream, it'll pull up a website where it has all of their different links and you just click to join their Zoom room. The court must hold a hearing if requested. If no hearing is requested and no opposition, the court can grant the order without a hearing. What I do is if I haven't been able to get in touch with the district attorney before the hearing date, I show up. I don't make my client show up typically because it's a waste of time for them to come downtown and to park when I have no idea what the district attorney is going to do. I talk to the district attorney and I say, are you opposed or not? If they're not opposed, we announce our agreement to the court signs the order very quick. If they are opposed, I ask if they need to hear from my client. If they do, then I reset it and I just get a new hearing date. I've also argued them without my client there. So I've done multiple hearings without my client and gotten grants. So just kind of weigh it. If the state is opposed to it though, you do have to prove to the court that you're entitled to this and explain what your eligibility and why you should get the order. I find it really helpful because of the law changes to bring in copies of the law for the judge if they're not familiar with it and just say like, here's what I'm talking about when I reference this. It's very helpful. And the court has to grant the petition if they determine that the person is eligible and it's in the best interest of justice.
We also have another question. What would be your advice to a client who doesn't really see the value in a non-disclosure? A lot of people believe that if it isn't deleted off their record, it doesn't matter.
So with a non-disclosure, it's still going to disappear off the district clerk's website. It probably won't appear on a lot of criminal background checks. You get to deny that you were ever arrested for it. You could deny that you were prosecuted. So it opens up a lot of opportunities for people. What I've also seen is that by getting the non-disclosure, it tends to take the sting out of the offense. So I had a gentleman who was in a single room occupancy with a drug conviction from the 90s. Housing wouldn't let him in. We got a non-disclosure. Even though housing was still aware of this offense, they let him in once he got his non-disclosure. So it just seemed to like help people understand that like, oh, you got it sealed. Now we can give you whatever benefit you need. And certainly I would say like with the Harris County District Clerk's website, anybody can sign up for an account. It's an email address and a password. And if they run your name, it shows up. And so if you don't want people running your criminal history and seeing like, wow, this person has all of these offenses, if you get a non-disclosure, they all just go away. And for a lot of my clients, they do qualify for fee waivers. And so what I tell them is that they don't have anything to lose. You know, I represent them for free. We file a fee waiver. It can be a pretty beneficial process for them. The worst that happens is the court says no. So I saw a question, since the expunction and petition only applies to parties named, could the mugshot still show up on the internet? Yes. So what happens with a lot of background check companies is they data mine all the public websites. So they data mine the district clerk's website to get their information for background checks. Reputable companies are supposed to be checking if records are expunged or sealed and then updating their records. That doesn't always happen. If you see that it's still there, and again, that's why I said like ask for copies of background checks, send copies of your order to that agency, and then they have to comply once they have notice of the order. So if you know that there's a public record of your mugshot somewhere, and I know like Brazoria County publishes mugshots, like they're readily available, send a copy of your order to them and see if they'll take it down. It's just not possible to include every single possible background check agency and private entity that could possibly have records. That could be like thousands of respondents, and the district clerk just isn't going to send notice to all those people. So we include the public agencies that are the most likely to have it, and then we kind of just arm our client like, here's copies of the order, you know, kind of be on top of it and let people know.
And just to follow up with that, we know that public agencies, they have to comply with that order. But do private businesses, like, I don't know, like if I created a website, mugshot.com, and I'm downloading mugshots and putting them on there, would I have to comply with that order if I'm a private company?
I believe once they have notice of the order, then they have to comply. So, but it's just an issue of like, you have to give them notice. So you have to send them the order. And that's like why we've talked about like how could we include more people, and it just becomes like impossible, like in terms of a paperwork standpoint for us to do it on our end. So we kind of have to like track it down and do it. And I did meet somebody from the Harris County Sheriff's Office, and she was the person in charge of destroying the records. So I was very glad to hear that they actually are going through and diligently destroying all the records after they receive expunction orders, which was like very nice to hear. It is being done. So this is the public information. So posters, announcements about fugitives that you may see like in the post office, original records of investigation that have to be maintained, you know, by law to be available to the public, judicial, administrative, and legislative proceedings, court records of public judicial proceedings, any published judicial or administrative opinions or announcements of executive clemency are exempt from the order. So permitted post non-disclosure. So who can see it after you get an order of non-disclosure? Criminal justice agencies can disclose the information to another criminal justice agency. For criminal justice agency of regulatory licensing purposes, there are 32 agencies that are listed in the statute that are allowed to still see the records. Those are things like school districts, Texas Medical Board, Board of Law Examiners, the State Bar of Texas. Basically any state licensing agency is going to be able to see it still. The petitioner, so you can get a copy of your own record. I have found that that does not apply to petitioner's attorney. So courts often won't let me have a copy of the order. So I have to ask my client if I can take a copy, make a copy of it, or take a picture of it so I can maintain it in my records, which are protected by attorney-client confidentiality. But courts sometimes won't let me have a copy. And then if you have to comply with federal law to receive federal highway funds.
Another question, does this mean if I have a successful expunction and choose to run for office someday, that expunction could resurface?
So that's a hard question. We live in a very different time, and you know, social media and the internet and all of that is great for a lot of reasons. It is also kind of a downside. When I was growing up and I was in high school, we didn't have cell phones with cameras. There was no video recording. So my youthful mistakes and stuff, nobody remembers those. There's no documentation of that. Unfortunately now, almost everything seems to be preserved somewhere on the internet. It can be very hard to track it all down and destroy all of it. So I would like to say that no, if you get an expunction, you get to deny that you were ever arrested. It should not hold you back. If you're running for office and somebody decides to do opposition research about you and they somehow find this random website that includes a picture of your mugshot, yeah, maybe it could come up. But certainly, you know, you can always explain, be like, I got an expunction. I'm legally entitled to deny that this happened. And more importantly, I was never convicted of this offense. I was arrested. It was dismissed. So I do know, I think there are some services, and I don't know how much they cost, but there are companies that will like go out and try and like clean up your public image, like on the Google searches and all the internet and stuff like that. So you can try and see if like one of those companies would be able to track it all down.
And if it does resurface, we can send them that order, and then they'll have to delete.
Yeah,
that.
I would say like this is supposed to be expunged, it's supposed to be destroyed. So please take it down.
Well, another question then would be, I had a client who received an expunction a year ago, and she contacted me and because she was now facing some immigration issues. Somehow the charge was still popping up on the background check. The problem was we tried to request the order, but of course Harris County deletes the files. So what would be the best action to take in that situation to try to get an order?
So that is the hard part about expunctions is, the district clerk will mail you a certified copy, but that's really the only copy. And then the expunction case itself gets destroyed. So there are no records of the expunction. And so that's really hard, is like you're trying to prove a negative, like it doesn't exist because I got it expunged. Hopefully your client has a copy somewhere. That could be the only thing that I could say, is like maybe she somehow has a copy somewhere of that original order. Like the clerk and everybody isn't going to have copies of that case because it's been destroyed. And again, that is the downside of immigration. Is I've talked to immigration attorneys and they're like, we don't understand the level of access that USCIS seems to have or the feds seem to have, but like it can pop up on immigration stuff. So like we always encourage people to be like, disclose it, because we don't know, like talk to an immigration attorney. They have creepy levels of access. So I'm trying to think, it may not have been long, like they have a while to comply with a statute. So it's possible that maybe one of the agencies still has a copy of it and they haven't fully destroyed the records yet. Just because I think, you know, it takes time to process these. So maybe just backtracking and saying like, look, we're just trying to get a copy of it to show immigration. But that's hard, yeah, because things are destroyed. It is one of the reasons why if I represent somebody, I keep records of everything, and I'm very clear with them, be like, so in addition to like, you know, these records will be destroyed on the public side, but I will still have a copy of everything. I will have a copy of all the underlying criminal charges, the indictment, the information, the dismissal, the petition, the order, because if you one day need a copy of it, at least I have a copy. Like at least it's maintained in our system for 5 years to 20 years. So
another question, for registered sex offenders, are there any exceptions? Like if both were teenagers, maybe 18 and 16, or are all expunctions for that denied?
So remember, expunctions are anything that are an arrest that resulted in dismissal. So they got picked up for a sexual related offense, but the state decides not to proceed with the charges, it's dismissed, and they get an expunction. If they did any kind of community supervision or deferred adjudication, then you're looking at a non-disclosure. And unfortunately, any offenses that require registration as a sex offender make you ineligible for a non-disclosure. They don't make you ineligible for an expunction. For people under the age who are charged as minors and they are in the juvenile justice system, that is a whole other world. That is, you know, a different process. It's under the family code. It's, you know, they can qualify for sealing, like automatic sealing of records depending on the level of offense. So I didn't include that in this petition because it is just a completely different process. Additionally, juvenile records are already exempt from public view. Like I can't go in and just look at somebody's juvenile criminal history, whereas I can look at their adult criminal history. So if you have somebody that was in juvenile court, I would recommend that they talk to their attorney and ask about the process for sealing. If they had a juvenile public defender, those attorneys have permission to do the sealing as part of their original like fee arrangement with the county. But yeah, if you have a conviction or deferred for a sexual offense and you're an adult, you're ineligible for an expunction. If you were able to get dismissed, absolutely go for the expunction. So kind of my eligibility summary, because I know it can get really confusing. And I've taught this class several times to students, and I know it's like something we all struggle with. If you're arrested and the charges are dismissed, expunctions. If you have a conviction for qualifying misdemeanor and it's your first offense, consider applying for a first-time offender non-disclosure. If you receive and complete deferred adjudication for a misdemeanor and a felony, look at a non-disclosure under 411.0725. If you are convicted, unless it's a misdemeanor and your first offense, or you qualify as a victim of human trafficking, it's staying on your record. If you don't successfully complete deferred adjudication, it's staying on your record unless you're a victim of human trafficking. So again, arrests that are just a dismissal, you've never entered a plea, expunctions. Everything else is going to be a non-disclosure, and a case cannot be eligible for both. So it's an either or situation. Either you're qualified for an expunction or you qualify for a non-disclosure. And the rules are completely separate. So if you're barred from ever getting a non-disclosure because of a disqualifying offense, that has no impact on your eligibility for an expunction. So kind of two separate worlds.
Okay. Another question, is a vacated felony conviction viewed the same as a dismissal for expunction purposes?
So there are options for people who have a felony conviction that has been overturned or vacated that would qualify for an expunction. So it's not a dismissal, but it's specifically listed in the statute as an option for an expunction. And usually what I've done before is I've had clients who had drug offenses that were convictions. Later turns out, not drugs. So the higher court overturned the conviction and then the state just dismissed the charges. And I just laid that all out in the petition and the state was like, down for it because it was kind of a dismissal, but then also was vacated. And I just let the court know, hey, here's what happened. Here's copies of it. And they accepted it and we're fine with it. Okay, and my last slide. So some legal resources, South Texas College of Law, Houston, where I worked until yesterday, has an expunction non-disclosure attorneys. They also have an ID restoration project. So if you have a lot of Class C tickets that resulted in failures to appear. So like if you have a traffic ticket, you don't show up and you get that failure to appear, they can help you address that issue because usually it can result in your license being suspended. Thurgood Marshall School of Law, it's my understanding they're not doing their clinic this semester, but they'll be back next spring and they're able to handle these cases. Beacon Law does a lot of ID restoration. They're kind of the experts in this area. So if you feel like if you are not eligible to get your driver's license because of tickets, definitely go to Beacon Law. There's a Make It Right event that is actually happening, I believe, the 26th through the 30th. So it is both your opportunity to deal with tickets through the DA's office, get screened for expunctions and non-disclosures. They are having a job fair with second chance friendly employers. It's all online. Go to Make It Right Houston. You can sign up. Great resource. I worked it last year. We screened a ton of people for eligibility. And if you have to represent yourself, Office of Court Administration has all the forms and orders for a non-disclosure. They're free, they're fill in the blank. TexasLawHelp.org, great resource. They have a lot of articles explaining the process, explaining what all the terms mean, and they have forms. So there's both the link for non-disclosures and for expunctions. And they're a great resource. If you're just kind of confused about, I can't remember what that term meant, go there, they've got a lot of links. And they're created by nonprofit attorneys, so it's a good resource. And then, yeah, Marquia also just shared it with Texas Law Help in the link. And I believe like I will certainly be more than happy to make my slideshow available, including all my notes that I have regarding waiting periods and what offenses qualify for which. And I will certainly make sure that Houston Area Urban League has that so they can share that with everybody, because I know it is a complicated process. So yeah, if there's any other questions, please let me know. I'm always happy to answer any questions.
Yes, we have another question. Can you apply for an expunction if the law changes in the future? For example, where marijuana is legal now, can I apply to have my record clean since the law no longer applies?
So usually what we're looking at is when they come up with these new laws, we always check to see, did they make the law retroactive? So did they say it goes back to all time, or is it limited to just cases from here on out? And that just depends on the way that they write the law. Our legislature meets every odd year, so they're going to meet in the spring of next year, I assume, with Zoom. And this is an area of law that changes almost every year. Not so much on the expunction side, but definitely the non-disclosure side. And so what we tell people is, you may not qualify today, you may not, but come back to us in the fall of odd years. We could screen you again, we can look at what the new laws say, and we can see if we can help you now. All those first-time offender non-disclosures, the resources for human trafficking, that came about in 2019. So before that, there was basically one option for a non-disclosure, and now we have 8. So definitely keep checking. And I know there's a lot of movement around possession. And even now, I think that the Harris County DA doesn't even charge it as anything more than a Class C ticket. And if you do the class, you get it waived. And I know that they offer that class at the Make It Right Houston event, or they were last time we did it, was you could go take that drug class and they would get rid of your case. But yeah, always double check, like ask if after the law changes, if you're eligible, because I think there's a huge movement in the clean slate movement to try and address these cases.
Also, during that period of while you applied for an expunction, you're waiting to hear back from the DA's office. You're not supposed to pick up any new offenses. Mm-hmm. What if you are charged with an offense that occurred before you applied for that offense? So let's say the statute of limitations on whatever this offense you've just received notice that, hey, I'm being charged with a new offense. Would that affect the expunction that I've already have going?
So it wouldn't affect eligibility. What I usually do is I say, like, I don't file expunctions or non-disclosures when my clients may have active warrants out for their arrest, because it's a really easy way for them to demand that my client appear in person and then get arrested. And I don't want my clients ever getting arrested. What I tell them to do is, at my old job, I was prohibited from doing criminal law by my funding. Now I'm at a public defender's office. It's a different situation. But what I would tell them is, like, you need to call your attorney and you need to figure out what you need to do. Like, how do you resolve this warrant? Then we can proceed. It is also harder to get non-disclosures if you have somebody with an active criminal case, because the DA is more likely to push back against that best interest of justice. Not going to matter for an expunction. I will say, if Harris County really does not like to agree to them if you have Class C tickets outstanding, so if they deny it because you have Class C tickets, like, go to Beacon, get those Class C tickets resolved, then they'll agree. So, but yeah, if you have an active warrant, like, call your attorney, try and get that resolved before you show back up into court, because if you show up in a courthouse and they run you, they can arrest you, and you really don't want to be in jail right now, especially during COVID.
Yeah. Well, thank you so much, Professor Ashworth, for everything. Thank you to South Texas College of Law, and congratulations again on your new position.
Thank you.
Thank you so much. Thank you to all the attendees. For those who were watching and those who are taking notes for someone else, thank you all for joining in, because you may have received something today to share with a friend, family member, or someone that could use this information. Thank you to Co-Chair Marina Banks of the Civic Engagement Committee for helping putting everything together, for running the show. Thank you to the Civic Engagement Committee, and thank you to all of the Houston Area Urban League Young Professionals. If there are any other questions, you all may unmute your mics now to ask any questions, or if not, feel free to send us. Also, will this video be shared? Yes. So we're recording now. We're going to save the video. The video will be shared with our Urban League Facebook page, and then anyone else that may need it, we can probably try to send that video to them. We also have the information on the slide, so we can share that information and contacts. If anyone is currently on the call that would like to discuss anything, please send us a private message and we can meet with you shortly after this call. But if not, thank you all for attending. If you would like to join the Houston Area Urban League, because I always have to give this spiel out, please hit up hallyp.org and look and check us out. We are always accepting new members. We love to get involved with our community. In addition to that, I hope that everyone found something informative. For those of you who have been with the Urban League, last year we also had a human trafficking event, and then you saw how today some of that human trafficking information tied in with what we have today. So we're always continuing, we're always learning some things, and we want to tie everything together. This is also something important because we recently had a protest in Houston for George Floyd. A lot of people were arrested, and a lot of people cases were dismissed then, so they are eligible for an expunction. So if you know anyone who was arrested at that time, please tell them to contact us because they are eligible for an expunction. So with that, thank you all again. Thank you, Professor. Thank you, Markia. Thank you to the Hall YP e-board. And with that, we close it out. Thank you guys, and we'll see you again at our next event.